Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. In this episode of the Future of Resolution, we have renowned family law attorney Randy Kessler of Kessler and Solomiany. Miles neutral Judge Jason Harper sits down with Randy to discuss his specialized practice, nearly every facet of the domestic mediation process, and his latest venture.
We are here today with Randy Kessler, who is a prominent and renowned domestic attorney, both in Georgia and nationally. Randy, it's our privilege to come speak to you today, and you take time out of your schedule to do this podcast with us.
Well, thank you. I'm going to call you Your Honor because it's a habit I can't break. I hope that's all right.
That's all right. You can call me Jason. There's no problem.
Okay.
Well, Randy, you've been practicing now for over 30 years. Is that right?
Thanks for reminding me.
1988. Is that when you graduated?
Time flies. I remember my first boss told me he'd been practicing 10 years, and I thought, God, that guy's old. You know, man,
time does fly. Well, if I have learned your background correctly, you graduated from Emory for law school. Is that right?
I did. That's what I was in undergrad up in Boston, and I just wanted to be below the Mason-Dixon line. It was too cold up there, so.
Now, you're not originally from Georgia, are you?
Grew up in New Orleans, and I'm a Saints fan, you know, black and gold, but I live here, and I love Atlanta, except for the Falcons.
Well, I was going to ask you, what kept you here? You never left after law school, did you?
It's just the easiest city in the world to move to. I mean, I've been in a lot of cities. We've all, you know, the older you get, the more you travel, and it's just an easy city. The people are easy. No one's makes you feel like an outsider, and it just sort of happened. Law school was great. I was enmeshed in the society as soon as I started clerking at a firm, and just there was no reason to leave. I just loved it, and if you don't love it, it's got a great airport, and you can go anywhere you want directly from Atlanta. So it's got, you know, best of both worlds.
Well, everybody knows you for your expertise in the field of family law. That's one of the things you're well known for. The question is, did you go to law school intending for that to be a specialty, or when you got out, did you begin immediately practicing in that field?
You know, I've thought about that a lot. I don't think I knew that I wanted to be a divorce lawyer. I wanted to be a litigator. wanted to be in court. In law school, I tried my first jury trial in the DeKalb prosecutor's office. It was a DUI. The guy was a .38. They gave it to me and said, "You can't lose this one." I said, "Don't say that." We won. And then when I started my own practice after being out of law school for 3 years, I took everything that came in the door. And the people that came in for family law, because that's what I'd done a lot of, seemed to appreciate it and were grateful. And the people that came in for the other stuff, traffic court, were hiring me because I was young and hungry and cheap. And so I just decided I liked the family law cases. It was more rewarding. I helped people with real-life problems that, and people that were older, smarter, wiser, richer than me, and they were grateful that I walked them through it, and it just was a feeling I'd never had before, so.
Well, what made you take the leap 3 years out of law school to start your own firm? Did you do that alone or with your partner at that time?
Did it on my own. I was not married, didn't have kids. I could eat peanut butter and jelly all day if I needed to, and I had worked in 2 firms, and I had been looking for a job, and every time I met with somebody, I thought, I can do that, you know, and I really just, what's to lose? And I talked to some people that told me the same thing. They said, if you're going to try it now, then other than when you have kids and dependents, and it just worked out. I've always been outgoing, always been easy to meet people, in the business generation was not hard.
I had a similar experience. When I left law school, I worked for the same firm that I had been a gopher from 16 on, so it was almost like working for family. Take everything that comes in the door as a new associate, but I gravitated towards family law, and that's just the area I became fond of, and I would say was better at that than the other areas.
But doesn't that help you? I mean, sorry to interrupt you, but I just, you know, we got 12 lawyers here, and every now and then someone has to do a garnishment. They've never done one, or they have a friend that's gone to traffic court. You know, you and I having done some of that, I think it makes you a more complete lawyer, having, you know, handled a couple criminal cases, you know, a smattering. We know what it's like, and we know what we like now, so I wouldn't change that experience for anything.
Well, do you find sometimes your domestic clients end up getting arrested for the misdemeanor, or they end up with the garnishment? Something happens.
Absolutely. You got to be a jack of all trades and master of none, sort of. It's issue spotting like in law school. That sounds like a tort. You know, he gave me a sexually transmitted disease. Well, maybe that's a tort. Maybe we should get a tort lawyer, you know, things like that. You know, what about the collusion? My husband was in a wreck and I got injured. Well, isn't there marital immunity? Well, if you're going through divorce, is it, you know, so yeah, those issues always come up.
What I found, and it'd be interesting to hear your take on it, in the field of family law, that is the most important thing in that person's life, usually at that moment, because you're dealing with the future of their children, the future of their finances, and things of that nature. not only is it stressful for them, but I found it stressful at times for me and my staff, meaning that we're having to handle those folks' problems. How have you dealt with that over the years, or have you found it to be an issue, or how do you get that balance?
So I've got two answers. One is I think you're absolutely right. It's the most stressful thing in their life for them. And you know, as a former family law attorney and a mediator, that you've got to teach them the process. You know, a person that wants you to write a will give you $1,000 and say, call me when it's done. A person that's going through a divorce is going to call you every day and say, explain how the process works. Can you cut off my credit cards? Can I change the locks? I mean, you've got to teach them the process, and they've got to learn how to do a divorce, and then hopefully they never need that information again. So number one, I like educating. But number two, the stress, how do you deal with that? That's why we have 30 people here. I know that when I get a call on a Friday night from a client who says, do I have to let her see the kids? She's not doing what she's supposed to do, and she's saying bad things about me, but do I have to follow the order? And when I say yes, and they say, that's what your associate told me, or that's what your paralegal told me, I know that somebody in my office already had that long conversation, and they're hearing it twice, so they take it. It's I've got it very good. I've got great folks here, and it's wonderful not to have to do it all myself.
How would you, or what would you tell a young lawyer or a solo practitioner who's having to handle those stresses alone? Did you have to deal with that when you first started out?
Sure. You know, the only way I can answer that is I remember I was on a panel for some young law students that asked the question, how do you not take this stuff home with you? You know, how do you turn it off at 5 o'clock at night? And none of us knew how to answer. And finally, we came up, the answer was, you do take it home with you. If you don't want to take your work home with you, then don't do family law. It doesn't mean you have to call the client all hours of the day. But if someone's really having a hard time and they're paying you a few $100s an hour, you may have to take a call on a Saturday or Sunday, and you may have to walk them through it. And next week, it's going to be the exact same conversation with a different client. But I don't know any better answer than it is what it is. And if you don't like it, there are lots of other jobs and lots of other careers. Some people enjoy it. I'm one that enjoys it, and I'm blessed to have found something that I like.
I began practicing after you. I think 9 or 10 years later is when I came along into the field. Even when I began practicing domestic law, the field of alternative dispute resolution, at least in the circuits where I practiced, that was either unheard of or a new phenomenon. It's just something we didn't do. We didn't mediate cases. You did discover, you filed a suit, you'd file the answer, you did discovery, you may or may not have a temporary order, and then you got your final. It was just a process you went through each time, and then they interjected, we're going to do mediation. And now it's become court-ordered in many, if not most, circuits. I got a few questions about that. When did that first come on your radar, that there was another option out there?
So I remember when I first started practicing in the late 80s, the older lawyers, it was like that movie, you know, we don't need no stinking badges, we don't need no stinking mediation, because the lawyers would know what's going to happen in court if they were good lawyers, and the lawyers would each say, you tell your client what you think's going to happen, I'll tell my client, and if they don't want to do it, then we just go to court. And they were right to some degree that a good lawyer should be able to predict fairly well what should happen. But I think mediation has taken off for two reasons. One is the catharsis, the fact that people have a need to tell. And you know, you sat on the bench and there had to be cases where someone just had to tell you about the misconduct of their spouse, even though it may not have mattered in how you were going to divide the furniture. If they can do that in mediation, then it saves the court time. And, you know, we're all taxpayers and paying for the judge's time. And I think the other reason it's taken off, you know, for good or bad, is that if I was a judge, and I'm sure you've experienced this, and you had 100 cases on your docket and you sent them all to mediation, if only 40 or 50 needed a trial, then why wouldn't you send every case to mediation if half of them came off of your docket? And I don't know if it was more or less. If 10 came off your docket, it's got to be a good, from the judge's perspective. But I think not just to clean the calendars out, I think it's a good process. It lets people get stuff off their chest. And wouldn't you rather craft your own result? And along those lines, and I know I'm going on, this may be one of your coming questions, but my goal for mediation, and this is going to sound terrible, my goal for mediation is not to settle the case. It's not to not settle the case. I mean, I do want to settle the case, but that's the secondary goal. The first goal is to get my clients to buy into the process so they understand that communicating and working in a mediation environment is 10 times better than going to court. They can go to mediation and they can say no. You, Your Honor, you come out and you say, guess what? I'm going to award $3,000 in child support, and the client says one thing, thank you. They can't say anything. They can't argue with you. In mediation, they can say, can I pay $2,500 and I'll also pay for college to offset so you don't have to save money? So I really just want people to buy into mediation. I think it's a great process, and it's a way people who decide to get married should get divorced.
You hit on something that I think, is goes across all spectrums of mediation, not just domestic, but a judge doesn't necessarily want to hear all the dirty laundry. It may not even be relevant, may not even be admissible, but do you find that even though you might be paying that mediator to sit and just listen, the venting session, can that be of benefit to let that client vent?
Unbelievable. It can definitely be a benefit. In fact, I had an experience last year that changed my view on mediation. We had a big case where my client was overseas and wouldn't come back, so he was going to be by phone. The wife was here, and there was a business that was trying to buy the marital business. So they had lawyers. There were 3 sets of lawyers, and we were having a mediation amongst all 3. The mediator said, here's what we're going to do. I'm going to meet with the wife on Monday with her lawyers. I'm going to meet with the husband on Wednesday with his lawyers. And on Friday, I'm going to meet with the business and their lawyers. And then we'll do the mediation the next week. And at first, I was terrified. I thought, that's not fair. She's going to get to prejudice the mediator. And then it hit me. The first couple hours of every mediation is venting, getting it off your chest. And by the time we sat down for mediation, everyone had already done their complaining about the conduct. So we got down to brass tacks. So that's a long answer, but the short answer is yes, absolutely. The venting, you can't settle a case unless you've told somebody why you're right and why he's wrong or why she's wrong.
Well, not to put you on the spot, but when mediation and the ADR process first came into being, is that something you either bought into, were skeptical of? What was your view of it when it first came to be?
So I have an ego, and I thought I could mediate cases, and I didn't need to be trained. So I thought the training was a little bit too generic. But I like the concept of it because there's some people that had never been in a mediation. They had to go through it. So forced mediation, I get upset sometimes with judges that force us to mediation, but I learned a lesson a long time ago. I was in court, and I had done everything I could to reach out to the other side, to buy them lunch, to try to work with them, and they just wouldn't respond, period. They said, we're going to court, we're going to court, we're going to court. So I walked into court, and it was a busy calendar, and the judge got to our case, and they said, so Mr. Kessler, you think y'all could step outside and see if you can resolve anything? And stupidly, I said, Judge, I've tried everything. There's nothing to talk about. We're just ready for trial. And the judge looked at me and said, Mr. Kessler. And I realized I just changed the judge's whole impression of me, that I looked like the one that was being stubborn. So even if it's just for appearance's sake, and there's a 1% chance it should settle, it's worth exploring. You never know what happens when you get in a room with somebody.
Well, not to put you on the spot in front of any judge that may listen to this podcast, but do you think a judge should or should not? Some circuits, let me back up, some circuits have a blanket mediation rule. Every domestic or civil case shall be mediated unless maybe there's a caveat for domestic violence or something of that nature. Are you in favor of such rules? Do you think it ought to be on a case-by-case basis, or what's been your opinion on that?
So I think every legal rule and every legal statute should have a caveat at the end that says, except for good cause or except in the judge's discretion, and that should go along with everything. I don't mind a blanket rule that tries to get people to mediation, but I do mind when judges are blind to the case where somebody's delaying the mediation because their client is the one in charge of the money, and the longer the mediation takes, the longer it takes for the dependent spouse to get in front of the judge and ask for temporary support or to see their children. So I think if a lawyer contacts the judge and says, we've tried to do mediation, I'm not opposed, and I've mentioned this to some judges, to the judge saying, here's what we'll do. We'll schedule a temporary hearing on Friday afternoon at 1, and Friday morning at 9, you'll do a mediation in the courthouse. And I think the idea of having a court date set will motivate a lot of people to get the case settled when you realize that mediation isn't a tool just to delay. But and there are some cases that can't be mediated, but you know what? Trying to see it from the judge's side, which is what I spend my life doing, I don't know that I can make a good argument to any judge why one particular case shouldn't go to mediation or shouldn't at least see if there's 1 or 2 issues we can resolve. So I'm not opposed to trying it, like you said, in any case except where there's domestic violence. I do think that emergency hearings sometimes need to be had, and I think that's dependent on the lawyer's reputation. You had lawyers, I'm sure, that cried foul and cried emergency every day, but the ones that don't do that every day but really need to get in front of you because the husband just cut the wife off the credit cards and changed the locks, and that's not a mediation issue. That's let's restore the status quo and then go to mediation. So there are times when I'd rather the court say, we'll have an emergency hearing, but it better be an emergency, Mr. Kessler, and I get that.
You mentioned going through mediation training and trying to learn the tools of doing it. That's what anybody would be required to do to be registered. One of my questions is, can anybody be a domestic mediator? Is there a special knack to that?
I think it's like being a trial lawyer. some people are just naturals and some people aren't. I think anybody can try it. And I think certain people are better for certain mediations. Sometimes a psychologist would be better. Sometimes a judge, a lot of times a judge would be better to be able to say, rightly or wrongly, that I've been on the bench and I can tell you probably what would happen. The reality testing is probably the most important aspect. But I think it's personality driven. You have to be a good listener. You have to strike the balance of telling somebody what you think and biting your tongue. You have to let the lawyers think they're the biggest shots in the room because, that's your business, your core business. If you're overriding and over-talking the lawyers, they're not going to use you again. So there are a lot of dynamics going on for a mediator, and it's I think it's a unique skill. And what's interesting to me is the people that you know of as really good mediators, Greg Parent, for instance, they're great people too. The people that you know that have a reputation for being a really good mediator are people you like being around and you enjoy seeing them. So I think likable, intelligent people are going to do better than people that are unlikable and doing it for the wrong reasons, for the money or for whatever other reasons. So I hope that wasn't too long of an answer.
No. You hit on some points. A domestic mediation may be different than a standard civil mediation where we're talking about simply monetary damages. Is there an amount to be awarded and how much? You could be dealing with children. You could be dealing with finances. There's a lot of emotions. And you mentioned sometimes a psychologist. You've dealt with some complex cases in your career that many of us are familiar with, having heard of them or seen you in media related to. They dealt with a lot of money. They dealt with children, lots of issues. When you go to a mediation, how do you prepare for that? Meaning, do you need the accountants to have information put together? Do you need a psychologist's report if it's dealing with the well-being of a child? How do you get ready for that?
So ultimately, all mediations come down to the client. I mean, I've had 7-foot NBA clients in here, and he asks his mother to leave the room who wants him to have a prenup, and he tells me, I don't want a prenup. I'm afraid she's not going to marry me. I want to marry her no matter what. It might not be the best business decision, but you got to know what your client wants, first of all. But yeah, when there's a lot of money, we bring in, I had a mediation for a law partner at a big firm a few weeks ago, and we brought in his financial expert, his accountant, his personal accountant, to be able to explain things. And it's not so much to explain it to me, it's to make sure that we're not missing anything. I mean, I'm good at law, I think. I think I'm good in trial. I think I'm good at hand-holding clients. I'm not the best forensic accountant. I'm not the best tax expert. I'm not the best bankruptcy lawyer. So if those issues are involved, I want them either in the room or on the phone. And one thing that I think people make mistakes on in mediation is a lot of times clients come in and they say, I want to know what we're going to offer and what we're going to settle for. And the hardest conversation I have with clients is, you're going to go in with an open mind. Let's have a general idea of what you're willing to do. You want to give her about $1 million. Yeah, but no alimony. I said, keep your mind open. You might end up giving her $800,000 in cash and $200,000 in alimony. Or you might give her $300,000 designated to pay for the kid's college. So you're giving her more, but she's got to use it. Getting them to keep their mind open and not sounding unprepared is hard.
You find that mediations are often like that you come in with one preconceived notion of the client of how we can settle this case, and you come up with something totally different, something like you just mentioned?
100%. And in fact, I try to tell my clients, you don't get settlement by saying no. If you came in with an offer and said to my client, here's the offer, and we said, no, here's our offer, that's not going to play well. How about if we said, yes, we accept it, but here's some changes to it? Saying yes gets you a lot farther than saying no. And getting my clients to realize it's not about winning, it's about letting the other side feel like they've won is going to get you a settlement.
Have you ever been to mediation where the other side is ill-prepared, meaning you just laid out how you would prepare and how you're not an expert and you might need help from those folks who are? Have mediations failed when one side fails to do that?
I think that happens a lot. And I don't want to, I'm high on family law lawyers. I mean, I love family lawyers. I've been very active in the bar, the family law bar. But I think one negative to family lawyers is that a lot of us are solo practitioners. And there's some great solo practitioners. But one downside of being a solo practitioner is you might get 4 cases that are all scheduled for trial or mediation or deposition in the same week. It's hard to be ready and on top of all of those. We probably go to the opposite extreme. We probably have too many lawyers, and we probably have 2 or 3 lawyers on a case that maybe one lawyer could handle. But I know that I'm not going to miss anything because somebody's working up the file, somebody's, available to cover for me in another case so I'm not distracted. So I think there are lawyers, for good or bad, that come in and they just haven't had the time to prepare. But I don't think most divorce lawyers are lazy because we get paid by the hour. So if you can charge someone 3 or 4 hours to prepare and they're paying you, you should prepare. I think another negative is that a lot of divorce lawyers get stuck in a circle where they think, my clients can't afford it, I got to do this on the cheap, I'm not going to spend a lot of money, I'm not going to prepare a lot because I want to save them money. And they may be right. But it's not fair if you're prepared and you're ready but you know, if that happens, it's an advantage to me because then I can explain to them and I can say, I do understand it, you don't understand it. Here, let me explain to you why the stock option is not really a benefit to either party. It's not going to hit for 10 years and my client's not going to stay there for 10, you know. Knowledge is power. I'd rather be ahead of the other side any day.
There are various ways that I've seen mediations work. One is the mediation does not occur until there's been a lot of discovery. That way everybody has that knowledge. And then there's been other cases where you discover something at the mediation that might be beneficial or not, but do you ever find that when you go, you learn something? It could be something that you might have thought you would have received in discovery or just trial strategy. This is where they're going to go when we get to court. Now I understand.
100%. The mediator can be your best friend. They can give you sort of insider trading. They can say, she is just not happy about anything. She's not going to settle anything. It makes you know, we just got to go to trial. You learn so much when you're out of mediation. Also, in family law, sometimes in early, you know, we have late case evaluation now as a new concept. Mediation doesn't work. We have an expert say, here's what I think is going to happen, settle or not. I'm not opposed to early case evaluation or when a parent is not getting time with their children. That shouldn't wait 3 or 4 months. There should be a temporary mediation, even if it's just on custody. One doctor and one lawyer, we've just been through this in the last month with both of them, weren't getting time with their kids. And there's no set of rules, right? If you're married and mom wants to take the kids to Disney World and dad wants to take the kids to Memphis, who wins? I mean, they can pull them. It's a tug of war. So at least getting some status quo, some stability for the children is what I hear from psychologists is best, even if it's not the result you want. Even if you go to mediation and since you don't have a judge telling you your client gets this much time, so you have to take less, it's something locked in. So I think an early mediation for parenting time is often beneficial.
The last domestic case I presided over was a child born to 2 unmarried individuals, so the child was not legitimate. The father visited with the child for the first 3 years of his life with no order in place, no legitimation. And then when he filed for the legitimation, that visitation stopped. Yeah. And there's no temporary legitimation. Right. So a child went for a year without seeing a parent, and there was no mediation resolution, and you couldn't get a hearing until you had the mediation. So do you find that, you know, sometimes a mediation, even if you don't resolve things in its entirety, have you ever gotten a temporary resolution or an agreement for a temporary order to try to solve some of those things that in the long run might be detrimental to somebody?
100%. And there is a trade-off. And I've had cases with judges that you know and respect where we've reached a temporary agreement saying, and I've put specifically in the order, this will not be precedent because my client agreed to this. He shall not be bound to this, and the court shall hear issue as if there was no temporary issue. And I've had the judge say, y'all have already worked it out. You got a temporary order. You don't need a hearing. So, you know, once you reach an agreement, and again, I try to put myself in the judge's shoes. They've got a lot of cases going on. And if there's a case where there is no order and people are in limbo and the next case has an order, I'm thinking, well, they came to some sort of accommodation, even if it wasn't perfect. I'm not as interested in trying to jump in and fix that problem as I am the problem where there's no order. So yeah, it's a dilemma. Do you take nothing? And of course, in the case you just mentioned, by the time the child hasn't seen dad for a year, you're the judge. You got to do what's best for the child. And it's probably not best to turn around and give 50-50 when the child hasn't seen the father for a year and you're condoning mom's bad behavior. It's a dilemma. It's tough.
How do you balance? You mentioned getting a temporary order or a temporary agreement at mediation that you may ultimately be stuck with. How do you handle when a client comes in and you feel they're making a bad call, meaning, Randy, just enter the temporary order so we can get out of here, and you know it may prejudice them in the long run? How do you handle those kind of situations?
Isn't that Family Law 101? You're at mediation, and you're at the end of mediation, and on one hand, you're worried that someone's going to back out of the deal, so you want to sign a memo and lock it in. On the other hand, you're worried that tomorrow your client's going to call you and say, I wasn't thinking about it. So I have one saying, which is when my client says, Randy, just if you tell me to sign it, I'll sign it. That's when I call it off and say, no, if you don't understand and want it. But that's a hard one, you know, talking clients into or out of. And something I've learned over the years is clients are right more often than we like to admit. You know, when I say you should not go to court because you are not going to achieve that result, and they say, well, I don't care, I'll pay you, I'd rather go to court. I'm not always wrong, but there are times when I'll be darned and the client was right and they should have gone to court. And what's interesting to me about family law, amongst other things, is how often we give people advice that's against our own financial interest. I mean, we go to mediation to try to settle cases to stop the clock and stop them from paying us. And I think that's what good family lawyers do. And I think in the long run, that's better for us financially because people give us recommendations or referrals. But it's just interesting when a client says to me, but you're telling me to take that settlement, you're not really on my side. And I think, okay, don't take it. Pay me another $50,000 and let's go to court and we'll see what happens. I mean, I am on your side. I'm trying to save you the cost of paying me and the unknown of this judge who may have had a bad day and not like the way you look at him.
You've practiced law for 30 years in this particular field. Are there times that you can tell a client, I've been there, done that, and I've seen the outcome, meaning I've seen 10 years later after the agreement or after the judge's order where this is going to end up? Do you advise clients basically outside of the field of law, but here's what happens to you?
Yeah, I think that's, one benefit of age is you recognize more and more how important settlement is and resolution and mediation. And even a young lawyer's been through it, but the older you are, the more you've been in court with a set of facts that you know are winning facts, that your side should win. You're on the side of right and justice and fairness. And for some reason the judge doesn't get it, or there's a piece of evidence you didn't know about, and you come away with a result that you didn't expect, it makes you think 10 times harder the next time you go to court. No matter how good you think your case is, a sort of good settlement is almost always better than a perfect trial. When all the other stuff that goes along with trial, the other side's not happy, they want to get vengeance, they want to appeal it, they won't comply with it. The other thing is, when you mediate an agreement, and you've seen this as a judge, I'm sure, sitting on the bench, when someone's not abiding by a court order, it's got to be different from the judge's point of view if it was a court-ordered resolution or if it was a mediated resolution. Because I'm sure if I was sitting on the bench, I'd say, sir, you agreed to pay $2,000 a month, so I understand it might be hard for you to pay it, but I didn't get this wrong. Maybe you got it wrong. It's got to be a little bit easier than when you ordered the guy to pay $2,000 a month and then you've got to second guess, well, maybe I made him pay too much. So settlement agreements are probably, and people are also more likely to go along with it. When I tell my client, if you don't pay this, you're in trouble, and they say, why? I said, because you agreed to it. You can't go and say the judge got it wrong. So I think it keeps people out of court if they settle a case, And you know what it's like. You go to court and you lose. You spend the rest of your life thinking, how can I get even? What's the next case going to be? When my kid gets to be 14, I'm going to have him sign an affidavit. Then I'm going to go back and get custody, and I'll show her, I'll show him. There's just so many reasons to settle. Well,
You bring up a good point. Divorce is about many things, money and children. That's what a lot of times it comes down to. Assets, that could be a house, it could be a retirement account, it could be, monetary account. That's one issue, and if you don't have children, maybe that's all you're worried about. But if you do have children, that brings a second dynamic into it. Number one, what's harder to mediate, the money or the children?
Children. I think every time the children. I mean, money, first of all, I got a little trick up my sleeve, which is I can say, my fees are going to be X. So now, if you don't have to pay me to go forward, that saves you $5,000, whatever it is. In custody, I mean, how do you convince somebody that they don't need the time with their children? I mean, I've got clients that get 49% of the time, and they're devastated that they don't have 50% of the time. I think children is always harder. The NBA clients, the professional athletes who, they want the time, but the law doesn't provide for relatives to take their parenting time, but what they usually want is their parents to be able to exercise their time. The grandparents want to have that relationship with the child. And how do you negotiate that? I mean, if you're a judge, I don't think you have the right to say, I'm going to award grandma dad's parenting time. You can just give dad the time and hope that, he works it out with mom. So I think custody is always harder.
You don't need to name names, and I know you wouldn't anyway, but are there times when you have both issues that one party barters the money for the children or, holds it out either as a threat or a carrot?
1,000%. And look, it doesn't sound right or fair or ethical, but I think there are times when it might be appropriate. If I made a lot of money and I was going through a divorce and my wife was just horrible, which she's not, she's wonderful, but if she was horrible and said, I'm not going to let you see your daughter, and I said, what if I gave you an extra $2,000 a month child support? It would be worth it. It wouldn't be fair. It wouldn't be right. But behind closed doors, I would probably do that because I'd rather get her to agree to give it to me than fight her. So, yeah, it's not fair. hopefully the judge can see through that. And we've had a case recently where the judge lectured the mom and said, you really don't want him to have a special schedule even though he travels. If you want him to come every other weekend, then he's going to have to switch jobs. You won't get private school anymore. You won't have the nice car because he's going to have to take a lower paying job. People don't take all the factors into account, but yeah, I'm sure you've seen it too.
In a mediation session, do things get more emotional about the children or the money, or is it just depending on who the clients are?
Who the clients are, I think it depends on what they want. And that's the biggest, that's the hardest part about mediation, is trying to figure out what's the other person's concern. What do they want the most? I gave a speech when I'd been practicing law 3 years, and I wanted to talk about how to get a downward modification if you can't afford to pay a lawyer to get one. And they didn't let me talk on that. They said, lawyers won't want to hear about that. So they said, how to enjoy practicing and worry less. Enjoy practicing family law. And I'd not done family law but for 3 years. So I talked to people, and I remember Barry Magoo, who was still a senior lawyer, but was much more senior than me even back then. And he said, listen to what the clients want. They may want the old jalopy, not the Mercedes-Benz. So, I think that's the art of mediation, is trying to figure out what is it that they really want. And the nice thing about family law is a lot of things are not quantifiable. If it was all math, if it was a personal injury case and there were damages and, medical bills to say, well, it's going to be 3 times meds or whatever it is. In our case, it is how important is it to her to stay in that house and to keep the kids in that house? Or how important is it to him to make sure he can spend the holidays with his family? And she might be willing to give him every Christmas because Christmas is not a big deal to her. So it's a lot of listening. And I think that's what's unique. And that's what I enjoy about family law, because you can find a solution if you listen hard enough.
A mediator, by definition, is a neutral. They don't take sides in the conflict. If anything, their goal is to bring resolution that everyone can live with. Do you ever do this, and do you think it's part of mediation process or appropriate that you need to know what are the hot button issues for the other side? Why are we here? Do you use the mediator as a tool for a fishing expedition and just tell them in a caucus session, can you try to get to the bottom of this for us?
Yeah, and I don't think that's unethical. I think I'm trying to figure out, what can I do? If she really wants the house, then forget my offer. Let's start working on a way to give her the house. If we are not going to settle the case without her staying in the marital house or staying in that school district, then why are we bothering with all the other stuff first? Let's figure out what's important. The flip side of that, though, is when you get your client what they want, the hot button issue. When your client really wants, and the house is an easy example, you get the client the right to stay in the marital house for at least 5 years, which is all he or she wanted. Then they start negotiating hard on all the other issues, and you've been there. No, I'm not taking $3,000 on child support. It's going to be $3,500 or I'm walking. That's when I use a mediator sometimes, and I look at my client and I say, remember when we started today, your number one priority was to stay in the house. If you take the deal, we walk out of here, you get to stay in the house. Isn't that more important than anything else? Do you want to... So it's interesting in family law how as soon as people win one issue, they win everything else, and our job is to focus on what are you going to feel good about 3 years, 3 days, 3 weeks from now, and what are you going to regret if you didn't take the deal that's on the table.
Part of mediation is just what you said. What can you live with and maybe not be happy with, but be comfortable with. But is part of mediation a risk analysis that you go over with the client, realistic expectations that this is what you want, but this is the risk of what we could end up with?
1,000%, and that's why someone like you would be a great mediator. So when my client says, is this as good as we can do? And I say, I don't think you could do much better, but let's ask somebody who's not only been on the bench, but somebody who's heard the arguments on the other side and can give us a neutral analysis. And if, we have a judge like you that can say, I've been there, and I think that your lawyer's right on target, or I think your lawyer's actually got you a better deal than most judges would give you, that's very powerful.
I did domestic mediations for 5 years prior to taking the bench. And then obviously I've resumed now. In order to resume, I went and voluntarily did the training again, just to get,
You're a saint.
Get back up to speed. When you went through it, you mentioned it before, it's more generic in the sense of they promote a collaborative effort. And the mediator being a neutral is absolutely neutral. But do you find that's the collaborative method? There is an evaluative method where you're going to a mediator partially for their expertise. You wouldn't just pick someone randomly for an important case. You need somebody who would have an expertise in that field. Do you find that a more evaluative approach or a case analysis approach with the mediator is more beneficial?
100%. My partner, Marvin Solomiany, has, by happenstance, started doing a lot of mediations because I think he's very much an evaluator, not a therapeutic touch. He tells it like he sees it, and there are cases where you need that, especially when we represent a lot of lawyers. And so it's hard to tell a lawyer to trust this person who's not even a lawyer, even though that person may have seen a lot more family law than my non-family law lawyer client. But absolutely, I want an evaluation. And look, sometimes it's me that's wrong. You know, Mel Westmoreland used to say it takes 4 people to settle a case and it takes 1 to mess it up. And I don't want to be the one messing it up. If I'm telling my client that you're going to get this much money or this much time with your children, and the mediator who's respected and done it tells me that they think I'm shooting high, I'm not shy. I don't mind my client hearing that. But hopefully the mediator's doing that to the other side, and I've analyzed it right. And the mediator, you know, sometimes clients complain to us. They say, well, my wife's lawyer is pushing her down this path. And we don't know if it's the client being aggressive or the lawyer being aggressive. That's something a mediator can help us with, too. The mediator can say, I was in there. And no, that's your wife that really wants that much time with the kids. And in that case, we can say to the mediator, well, you know, do you think the lawyer's giving her good advice and a good, you know, and most mediators would say, yeah. And then when the mediator tells us, here's what I think is going to happen, we can say, are you going to tell her the same thing or him the same thing? If they say yes, I have people that call me the next day and say, we settled the case after we got home from mediation because we both thought about it. We both love the mediator and we stopped listening to the lawyers. You know?
Do you think that some folks, let me say, they would say that an evaluative process at a mediation, particularly by the mediator, goes too far, meaning you've left the neutral zone and now you're the advocate for one side or the other. Do you find that there can be a balance, meaning a mediator can say, this is what I've seen in the past without unduly influencing, you know, giving that risk analysis to the parties and the attorneys without crossing the line?
Sure. Well, I mean, 100%. And that's the skill set of the mediator. If the mediator can say, if you want me to tell you what I think is going to happen, I'll be glad. You know, we've got one where we did the whole late case evaluation. We mediated, and we told the person not to give us their opinion because we were going to keep trying to negotiate, and we're going back. But, I mean, I want somebody that's going to tell them what to do, because in family law, as you know, sometimes you get control freaks. You get a person who, you know, shoots for the sun and hopes for the moon, and that's not the way it should be. If someone says, I know that she is terrified of custody, so I'm going to offer her no money in exchange for letting her have custody. And I'd like a mediator to go in the room and tell that person on the other side, she's going to go to court and she's going to get custody and she's going to get money. And she's getting the backbone built up, and, you know, that might be what persuades the person. So I like the fallback position of letting the mediator do an evaluation or doing a reality check. Not at the beginning. I don't like when a mediator blurts it out and says, well, I don't think that's what's going to happen. I mean, also, a good mediator, I think, is going to say, I've not heard the whole case. I've heard a little bit from your lawyer, a little bit from the other lawyer. My gut feeling is this is the ballpark area, but I've been wrong, you know. But if it's way different than the advice the other side's getting, that might help move them a little bit. Especially if it's you, if it's a judge. You know?
Well, not to put you on the spot, but I have seen this many times, and get your take on whether it's appropriate, whether you've used the tool, and that is a client has unrealistic expectations in the mediation, meaning
never happens.
You've gotten to a point that you, in your mind, think this is a really reasonable deal, probably better than we're going to get in court. I just need to get the client over the hump. Do you ever meet privately with the mediator or, you know, without the client and just say, listen, here's an area it would be probably helpful if you emphasize when we go back in, not play the mediator against your client, but to help prompt, let's have this discussion with the client?
Yeah, I probably would do that in front of the client because I'm being honest with the client, and I'm make sure the client knows I lose money by pushing you to settle. But I want the mediator to tell me that I'm giving you good advice if they think it's good advice. So I probably would do it in front of the mediator. But on the flip side, I've probably had more cases, more than half our cases that settle at mediation, settle with some version of, we've been there 6 or 7 hours. My client says to me, can I just go talk to my wife or my husband without anybody or with the mediator? And they go talk and they look each other in the eye, and that's the only way to know when someone's really at their wit's end. I don't think I've ever sent a letter to the other side saying, here's our offer, and gotten back a response saying, that's great, we accept it. Because you don't know when someone's really at their bottom line. But, you know, when a wife can look at her husband and say, you're not going any further than this, are you? And she can feel in her bones that that's not she's not gonna get any more than that. That's the best way to get a case settled sometimes. And so you can't. And then what I really find interesting or ironic or funny is when the clients come to us and say, "See, we didn't need you. We got it settled ourselves." Well, forgetting the dynamic that got them to that point of desperation and fed up and seeing the clock tick, and they're paying 3 lawyers and a mediator and a paralegal.
Do they ever get the sense, in your opinion, that the client feels like this is our last best hope of settling? If we miss today's chance, we're going to end up in court?
I think they do. That's why I don't mind someone buying into the process and saying, "Let's come back for another day," if they start to like the process. But yeah, I mean, especially when there's not enough money to go around. And what is sort of counterintuitive though is a lot of people will say, "I don't want to spend a lot of time in mediation because I'm paying you, he's paying his lawyer, we're paying the mediator." And I try to explain to them, that's your best use of money. When you call me tomorrow on the phone, I'm going to stop working with someone else's case. I'm going to have to get back up to speed on your case. I'm going to hang up the phone. I'm going to put it to the side. You want somebody that spends their entire day trying to get you some resolution.
Well, being a mediator, obviously, I think it's money well spent. But
Sure.
Clients look at the, I don't think lawyers so much necessarily, but clients probably look at the mediator's fee and think, we're paying something extra. We're in the judicial system, we're paying something extra. But in the long run, even if you pay a mediator an hourly rate for their expertise, if you cut out the lawyer fees preparing for trial and the time of trial, does it not come out potentially much cheaper in the long run?
Much better. Look, there are also times to take it a step further, and I don't know if y'all do arbitration. I'm sure you do. So, in California, they have fancy words for it. They call it private judging or private special masters. And a lot of our clients can afford it. And we say, well, you might pay a judge $500 an hour, and yeah, that's going to be an extra $5,000, $10,000. But guess what? You're going to get a judge that's going to take their time and think about it. They're making money. If they've got 800 cases on their docket to clear out this year, they're not going to give you as much time and thought. And wouldn't you want the person making the decision to feel like, I can go home and think about it, even if it costs you a few $1,000s? And again, you got to have the money to do it. But same concept. You get what you pay for. Same thing with the quality of mediators. You can get a non-trained person to be the mediator, and you'll get nowhere. You get someone who understands that when someone's just off the deep end, they know to come in and say, "Randy, today's not a day to settle it. I don't want to charge any more money. Just call it a day. It's been 1 hour. Maybe she'll take her medication and come back, in a couple weeks." So absolutely, a good mediator is worth every penny.
I've heard, both as a mediator and even when I represented folks, that the client has an expectation that the judge is going to go over every minutia of their assets, every piece of income. They're going to dig to find and make it fair. A judge, a Superior Court judge, has capital cases pending and a felony calendar and a lot more divorces and child custody cases than that particular client. Do you have to? You make a good point. If one person is doing that, whether it's an arbitrator or special master or even the mediator going through that paperwork, you have to convince the client you're getting more attention to detail that way than you would in the courtroom. It's not going to happen as you see it.
It's funny. Yes, we have to go through it, but a lot of things in family law are counterintuitive like that. So it's as soon as you explain it, all of a sudden you see the light bulbs go off. They say, well, that does make sense. I can pay somebody, and they actually think because they're paying them, they're going to be on their side, which we make it clear they're not paying them. The marriage is paying them. But yeah, we do have to have that initial discussion. But I think people that can afford it love the idea. I get to choose the judge, and especially if they think I'm choosing the judge or I have a part in who it's going to be, they think they're going to get a better shake, and really that's just going to get them the better chance at a neutral, fair decision because hopefully the other lawyer and I came up with somebody we respect. But yeah, it just gives them more control over their own future, and also you can do it where you want. You can do it at Miles Mediation or do it at our office. Instead of going to the courthouse, waiting in security, all of a sudden the judge has an emergency matter that's got to put everything else aside, and the judge didn't realize he's got a bar event he's got to speak at 5 o'clock, so they'll have to come back the next day, and then it doesn't get finished by Friday, and he's got a calendar on Monday, so it's 3 weeks later before you continue it. All those problems, money solves a lot of problems, and it's not that you may get the same result, but you'll get it faster, you'll feel like you've been heard. I just think it's the wave of the future. If, of course there's feedback, and I've seen this online, where people say it's not fair, it's unfair justice for the rich. Well, I sort of think it's like the hot lanes. People that are paying to be in the hot lanes, well, they're subsidizing the tax dollars for everyone else. You know, they're paying, and if you're going to pay for that, you're getting out of the way from all the other cases. But you know, there's always, is it philosophically right to be able to buy the judge that is going to make your decision? You know, we could talk about that all day, I guess.
You bring up a good point, and that is outside of the mediator and the mediator's capabilities or expertise, there's a comfort level in mediation, meaning, one, you can go to the mediator's office. And in our case, obviously, we're at Concourse Plaza. It's a pretty comfortable facility.
Sure.
And that's part of it, to try to make people feel at home and give them their own space and their own room to have privacy. You could go to an attorney's office, and the mediator could come there, assuming both sides are agreeable which office you'll go to, and not feel like they're on enemy turf. But the third option, the last time I visited, not as a litigant or a mediator or anything like that, I just visited it, was a local ADR office where mandated mediations go there unless you pick your own mediator and location. You have to go there by default. And, you know, it literally, I felt like I was going into a correctional institution. You go in, there's no chairs in the waiting area, and you literally go up to a window, tell who you are, and a deputy buzzes you through. There's one single desk with an armed deputy who buzzed you in. You're assigned a room, sheetrock, white walls. It could not be more, you know, just as plain as it could be. I thought, how can you be comfortable when you feel like, you know, you're going through security and you're in this uncomfortable facility? Do you find that it's much better to pick?
Absolutely. I mean, look, I was telling you earlier, that's why we created our office and put a lot of extra conference rooms. We'd rather be somewhere comfortable. People are making life, you know, changing decisions and thinking about things, and it does matter. You can, you know, if you're forced to, you make a decision wherever you are. But if you can sit back and think about it and say, listen, my dad's in the lobby, can I go spend a couple minutes with him in a private room? And there are facilities there that are comfortable for, you know, the client's father or mother to go do that. There's so many options that you can do if it's at your office or a private place. But you're also saving the taxpayer dollars. I mean, we're all paying for the alternative dispute resolution offices and staff. They're overworked and they're busy. The more we can alleviate their burden, the better. So, yeah, I'm a very big fan of private mediation in a private place.
You brought up family members, and even in our office, we have several break areas and waiting areas where folks could come if they wanted to with their loved ones. Do you find it helpful or harmful or case-by-case basis when the client, you mentioned a client bringing their mother, can that disrupt a mediation as much as help?
I think it helps 10 times more than it hurts. And it sounds, again, these things sound counterintuitive when you first hear them. You know, a mother whose daughter can do no wrong, of course it's going to be a problem, is what the natural reaction would be. But if you think about it, what's going to happen after the case, after the mediation? My client's going to go home to her mother or call her mother and say, here's what we did. And the mother's going to say, well, you didn't even think about this? You didn't think about that? I'd much rather have the mother buy into it, because that's who is going to have the ear of my client, and that's who my client's going to listen to when they leave my office. So if I can meet with the mother and my client, or the father or the uncle, and say, let me explain to you why this deal makes sense, it's much better than them having to translate my advice, the client translating my advice. I had one client in here once whose dad kept calling during the mediation. And we were caucusing, it was just me and my client, and her dad kept calling. And finally she said some words that I'll never forget. She said, Dad, look, it's like I'm in the operating room and I just want to stop the bleeding. You're in the waiting room and you want the scar to be perfect. First things first, let's just stop the bleeding and finish the operation. And I thought that was pretty interesting the way she saw that. So,
how do you deal with that tactfully when you need to kick the family member out and try to deal with your own client, who is your client, not the other party?
And if the family member may be paying our fee, it's still the client is the client is the client. You just have to put your foot down. If you lose a case or you lose a client or you alienate somebody, you do it. But I don't mind them having, if there are people that are more dependent on family members or somebody else or a preacher or a confidant, and if they're going to talk to them afterwards anyway, again, I don't mind them being, in the loop, but I do need to sit with my client privately and say, look, I don't know if your confidant knows this, but the fact that you've been doing drugs for the last 10 years and no one knows it, that's why you should be taking this deal. And I can't say that in front of your brother. So, yeah, there are times you need to be alone with your client.
You and I discussed this, but I think it's something that everyone listening would find extremely interesting, and that is, I wanted to ask you about average time that you think for mediation? What's the shortest mediation you've had, and what's the longest? You were telling me how late you've gone sometimes. Just share your experience about the variety you've had in the length and times of mediations.
So we've had them that I've been at the courthouse. I've been in Cobb County until 3 or 4 in the morning. The judge said, we were there for an 8 o'clock calendar call on Monday. He said, I'll give you till Tuesday morning, but you're here at 8 o'clock Tuesday morning, settle or not. Well, we finished the case at 4 in the morning. We had forensic accountants. We got it done. But we didn't know what to do because we couldn't call the judge at home and say, can we not appear tomorrow? So we went home, came back 3 hours later and settled the case. They're usually more than 2 or 3 hours, especially if it's the first one. Because again, that catharsis part, the hardest thing I think about the timing is to explain to my client that the first hour or two, the mediator may be with the other side. And don't worry, they're not getting on the other side. They're not getting aligned with them. What they're doing is listening for holes and places they can make them move or where they might change their offer a little bit. So I think an hour or two with each side before you even get to the meat of the case is very common in our cases. So I can't imagine a mediation going less than 3 or 4 hours. And that the quickest we'd ever have would be 3 or 4 hours. And if it's 3 or 4 hours, I don't think it's going to settle. So I can't remember settling a case in 3 or 4 hours. I can't remember coming to a whole settlement. I've come to an agreement to dismiss in less than 3 hours. I've come to an agreement to keep the status quo. I've come to an agreement to come back to mediation. But we've never got a comprehensive settlement in a complicated divorce in less than 6, 7, 8 hours at the very minimum. And usually, you ask how long they've gone. I'll give you one other example, and I won't name names, but we had a case. There's somebody very well known. They had $30 million to divide. So we had a mediation. They divided it $15 million each. And I thought that was great. Thought we were done. 4 mediations later, we were still arguing about paraphernalia, paintings, cars, and we ended up going to court on extracurricular decision-making on just extracurriculars. We still had a hearing just on that issue. Somebody wanted to be heard and somebody didn't want to give in. But that case where I thought we'd done a great job and settled the whole case, the first mediation, we had a mediator, we had a former judge mediate the next 4 times, and then we had to go to court on the last issue. So, when you think you're doing good, you never know.
I saw a clip of you on, I think it was Headline News, talking about the Jeff Bezos divorce. I know you don't represent the Bezos. That'd be a great client to have probably, but...
Oh, maybe.
Where do you see that case? Is that a case that they're going to try to keep out of court by mediating informally, or where do you see such a high-profile case going with no prenup, I understand?
So that's the one that's fascinating that we all think about. Just, when you're, an up-and-coming divorce lawyer, you want to have a case that's challenging and has those kind of facts. Of course, a case that has 1% of those assets is still $1 billion case. So that case, what I would do, I would conspire or collaborate or cooperate with 4 or 5 of my competitors and say, let's get the top minds in here. And the other side would do the same. And let's figure out, and my biggest fear would be, how do we not make a mistake? How do we make sure that we let these people go where they're both in good shape and we don't ruin the company? It's going to settle. There's going to be mediation. I think in that stratosphere of income, if one side only walks away with 10%, that's $13 billion. I mean, it would be a disaster for them and their family if they couldn't settle it and had to go to court. But, you see cases like this. The McCourt's case, the people that own the Dodgers, they went to court because they wanted that one item. They wanted the Dodgers. So if I cannot imagine that business lawyers are not going to give them the best proposal for how do you ensure the health and stability of Amazon and your other entities. And it may be that one of them gets it and the other one gets a payout, or one of them gets that, the other one gets a sub-company. But it's mind-blowing to start to think about how it's going to settle. But going to court would be the very, very worst thing. And I think they're not on the path to court. They've already issued that joint release statement that they're working together. You haven't heard much about it in the last few weeks. But if there's a case that calls for a second, third, fourth, fifth, sixth opinion, by all means, that's it. The first thing I would do is say, you're going to get a second opinion. I'm going to give you my advice. I'm going to bring in some people from, maybe even from another state, just to get, make sure they've gotten every bit of advice they can. I represented a famous athlete once, or I was on the other side, and his local lawyer from another state who had handled the original case said they were just referring it. I said, good, we'll work on it together. They said, no, you can handle it. And I thought, if you have $100 million and you have a heart condition, you have your pediatrician come and stand by the side of the operating table because you can afford it. So that's the way I would look at a big case like that. And I love thinking outside the box when we have cases that are really big that you just think, what can I do that's not because I'm just a family lawyer and you're supposed to ask for temporary hearing, create a joint account that says they're each going to take out of this and no one has to put any money in because there's enough money to fund them for the next 6 months. Just it would be interesting on a lot of levels. But honestly, it would scare the heck out of me.
Well, the Bezos case may not be a good example because it's too complex, but you deal with some cases that are complex. When you go to mediation, is it better to provide the mediator with background materials prior to the mediation so they're up to speed to some extent, or do you anticipate that 2 or 3 hours that they spend with each side will be to bring them from scratch up to speed? How do you usually approach a mediation like that?
So it depends on the mediator. But I would almost always prefer to give them an outline, a little notebook saying, here are the basics, because that's what they're going to do at the beginning anyway. Let me see the financial affidavit. I don't want to come in and tell a mediator, this case is worth $1 billion and have their eyes light up and say, wow, now I've got to change my mindset. I'd like them to know when it starts, okay, this is a case that probably has, or if it's an athlete or if it's somebody, they need to know something about it so they can just adjust. It's sort of, this is going to sound silly, but whenever I get a client, a new client, and I add them to my cell phone so that if they call, I know who it is. I try to find a picture of them. So that when I get a cell phone call, and I give my clients my cell phone, if they call me, their picture shows up so that I can be ready and say, that's who that is. And it psychologically does something for me to know, all right, that's that person. And I think knowledge is power, and I'd rather give the mediator more information. I've always, kept my mind open. What can I do? I've been active in the bar. I've written some books. I like teaching. But I have a sister-in-law who used to be the CMO, Chief Marketing Officer for LegalZoom, and she got me involved in a divorce app that we're working on, and she lives in Silicon Valley. And I had an idea for her and her team that they fell in love with, and the idea was this. I call it the Happy Birthday app. I represent some famous people, some ball players, some actresses, and reality TV people, and every now and then, my friends, my wife's friends, my kids' friends will say, hey, can you get one of your clients to do a video for my kid for their birthday or for their bar mitzvah or for whatever it is. And, it's sort of awkward, and sometimes I can do it if it works out. Sometimes I can't. But I just thought there should be an app for that. They love the idea. We put it together. It's now starsona.com, and it's an app in the App Store and on Google Play. And what you do, you basically go onto the app, you search by whatever you want, New York Jets or hip-hop, and you find your favorite athlete, singer, TV personality, newscaster, and you script what you want them to say. I'd like you to wish my kid get well from her injury. She wants to be a newscaster, but she's terrified that because she broke her leg, she's not going to be able to be on camera. And they send it to Jovita Moore or Brenda Wood or somebody that's on TV. And that person gets a notification, does a video, and says, hey, little Julie, you keep up the hard work. I broke my leg when I was in high school, and you know what? I still turned out just fine as a broadcaster, and not only that, my foot's even stronger, and I can kick these male anchors behinds, or whatever they say. And then the person gets the video, and the star gets 75% of the fee, and they can give it to charity or to their foundation or whatever they want to do with it. And it's just a way for them to spread their brand. And then, Julie gets it. She gets the video, and then she loves it. She shares it on her Instagram and Twitter, and all of a sudden everyone thinks, that was really cool that Jovita Moore did that. So it spreads Jovita's brand. It spreads the word about Jovita's foundation if she has one. It's a win-win-win. There's no cost to sign up. There's no cost to the stars. It's, and if you think a star is costing you too much money, like you can't find Kobe Bryant, who would probably be $10,000, you can find someone who played with him, a guy named Josh Powell, who's charging $20, and he won 2 NBA championships. And he can say, oh, I'll tell Kobe about you, but you keep up that, move and you'll be just like the Black Mamba, or.
Well, Randy, as we wrap up here, I was going to ask you, where do you see the future of ADR as it relates to domestic cases in Georgia in particular? We've moved from mediation, now we're beginning to see arbitration and things of that nature. Where do you see it going?
I think it's exactly where it's going to be for a long time. I don't know if there's that much further it can go. I think the cream always rises. I think, first mediation happened and people were resistant. Now they're open to it. Then I think a lot of people thought, and we talked about this earlier, I can be a mediator. So, and really there's not a lot of requirements to be a mediator, right? You go to the course, you take the course, you go through it. So, but the cream rises, and there are people, the family law attorneys that I deal with, we know the handful of mediators that we trust and respect and like the way they interact with us. So I think you're going to have a rising to the top of mediators. But I can't imagine being a lawyer and walking into court and having the judge look at me and say, have you tried mediation? And having to answer, no, I haven't. So I think it's now in the back of every divorce lawyer's mind. You have to try mediation, even if you don't think there's a chance that the SOB on the other side would even, be anywhere near reasonable. It's I just think it's here to stay, and I don't know how you feel. I can't imagine that mediation is going away.
Well, we'll end where we began. We talked about the stresses of law practice and family law. You have done many things. We just talked about the Starsona app, which you created in the website. You're the editor emeritus of the Family Law Review for the State Bar, and you've chaired the family law sections of the Atlanta Bar, the State Bar, and the ABA, and I can't count how many books and publications you've made and presentations that you have made to various groups and TV appearances. You do other things other than just practice law. Do those help you? I know people have to put food on the table, and those single shop lawyers have got to feed their families, but do you encourage that other folks branch out?
I mean, it's fun and I enjoy it, but I'm lucky. I found a passion that I like. I like family law, but it makes me such a better lawyer to be involved in the American Bar Association Family Law section and to talk to lawyers in Colorado who say, "What? You have a jury trial? What's that like?" And then I realize, wow, there's some benefits to that I didn't realize. Or to go teach a seminar in South Carolina, and they say at their temporary hearings, you know what they do? They bring affidavits to the hearing. They don't give notice ahead of time, and there's no live witnesses. And so I learned how they do things, and I come up with ideas that, it just makes me a more open-minded, stronger lawyer, I think, to be around divorce lawyers a lot. So I love doing this. Writing the book made me think through what would I want my family member to know before they met with a lawyer, and that was the guiding principle for the divorceprotectyourself.com book. I don't know. I'm lucky. Some people find what they love their first shot at it, and that was me. And some people struggle and they go somewhere else, and all of a sudden they're 40 years old and they find their calling then. I got so lucky. People ask me, where do I want to be, when I'm 60 or 70? I want to be where I've been for the last 10 years. I got great people, got great clients, and it gets hard. And you get clients that are unhappy and clients that are frustrated. But all in all, I wouldn't change my life for anything right now.
Well, Randy, it has been a pleasure to hear your take on various issues related to ADR and sharing your expertise with us. I want to thank you for taking the time out of your day. I know you're very busy to spend some time with us on this podcast.
My pleasure. You guys are great, and I can't wait to mediate with you sometime soon.
Sounds good. Thank you.
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast, Stitcher, Spotify, and subscribe, rate, or review this podcast. Join us soon for another interesting discussion. Thank you for listening.